on corrections will now come to order. Will the clerk call the roll?
Herrero.
Present.
Cassell.
Present.
Allen. Jones.
Present.
Lopez.
Present.
Murr. Sherman. Swanson. Toth.
There's a quorum present, members and audience. Everybody, thank you for being here. Please note that as members come in and out of the committee, we're having to lay out bills in other committees as well and tend to other matters related to constituent issues and or legislation. So note that whether or not we are all here present, your testimony is being received and considered and noted by members of the committee and will be taken into consideration as we consider the legislation that is proposed. The other matter is because we are being broadcast live through the House of Representatives website, I ask that you please refrain from videotaping and or taking pictures in here while we are taking testimony. There will be a time limit also of 3 minutes per witnesses testifying. The order of the notice is not the order in which we will be taking up the legislation, and that seems to be it. There is a housekeeping matter, members of the committee, that I'd like to address now. There's needing to be a correction of the minutes for the April 12th hearing. A bill was mistakenly recorded as having been reported favorably as substituted. The minutes will be corrected to reflect that the bill was reported favorably without any amendments and or substitutes. So if there are no objection, I move that we correct the minutes for the meeting held on April 12, 2023. Is there any objection? Hearing none, so ordered. We'll now jump into the consideration of legislation. Right. We'll take up Representative Howard first and then Representative Canales. So at this point, the chair will lay out House Bill 4020 and recognize Representative Howard to explain the bill.
Thank you, Mr. Chairman, members. According to the Centers for Disease Control, men and women with a history of incarceration are in worse mental and physical health than other Americans. Studies have shown that when compared to the general population, inmates are more likely to have high blood pressure, asthma, cancer, arthritis, and infectious diseases such as tuberculosis, hepatitis C, and HIV. For women, the situation can be even worse. Oftentimes, women who have been incarcerated have a history of addiction, domestic abuse, and sexual violence. They are also more likely to have experienced childhood trauma, physical and sexual abuse than other women. These factors could potentially explain the high levels of mental health problems among women who are incarcerated. While incarcerated, inmates have the potential to access healthcare services through a contract with TDCJ and the University of Texas Medical Branch. However, there isn't a guarantee that they will continue to have access to healthcare services upon their release. HB 4020 seeks to address this issue by directing TDCJ to work with HHSC to assist in the completion of, acceptance, and processing of eligibility applications for public benefit programs for inmates for the purpose of providing benefits upon release. The programs that are included in this bill include Medicaid, CHIP, Healthy Texas Women, Family Planning, TANF, SNAP, and WIC. The reentry process is an opportunity to provide people with essential health care services within their communities. Linking people to health care services post-release may help to improve the health and well-being of those with a history of incarceration, which could lead to a decrease in recidivism. HB 4020 seeks to improve the overall health of incarcerated Texans by ensuring that inmates who are eligible to receive health care services are actually able to do so. At this time, I'm happy to answer any questions and reserve the right to close.
Thank you. Any questions, members? Thank you, Representative Howard. Chair recognizes that Chair Howard has reserved the right to close on her bill. Chair at this time will call Charlie Maloff. As everyone comes forward to testify, and I don't know, a lot of you already know this, but please state your name, your full name as you registered. who you're here representing and then what your position is on the bill. So it'll either be for, on, or against the bill. Please proceed, Chairman.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Charlie Maloff. I'm the acting vice president representing Texas Cure and we're for House Bill 4020. Generally, an inmate goes into parole review 180 days before their hearing. It's during this time that their parole packet containing a home plan and job plan is submitted. This bill allows certain inmates to begin the application process for certain benefits. While we are for this bill, we respectfully request the author to give consideration to amending the time frame to upon seeing reentry. The reason is, in addition to staff shortages that may prolong the process, it can sometimes take more than 60 days to implement certain programs. While the bill provides for waivers, that process too can take more than 60 days depending on the agency. An inmate generally sees reentry twice. The first time is to identify what documents the inmate will need upon release, such as Social Security card, driver's license, birth certificate, etc. The second time, generally after they've been approved by parole, they sign for the documents, which then go into their release packet. It is this first time that the inmate should begin this application process. This bill will go a long way into relieving many financial, medical, and other burdens until the parolee or family can get on their feet, and timely implementation is imperative. Thank you for the opportunity to present our support for this bill and your consideration.
Thank you, Charlie. Any questions, members? Thank you so much. I'm going to read it as it's typed in. It may be a typo, but Marcu Simmons, M-A-R-C-U Simmons, S-I-M-M.
That's me. That's
Oh,
not going to testify.
okay.
Martin Ford, please.
I'll need you to come up, though, please. That's the benefit of being up here, is that we get to remember some of the people's names. So thank you for being here. So just for the record, state your name and then the correct spelling, obviously, and then who you registered on behalf of, and then what the position is, and then the fact that you didn't want to testify.
Yes, sir.
All right, please.
My name is Marcy Simmons, and the correct spelling is M-A-R-C-I. I apologize. I just drove in from Dallas, and I
Completely
haven't
understand.
even taken a breath yet.
Yeah, no worries. Yeah.
I'm representing Statewide Leadership Council, Lioness Justice Impacted Women's Alliance, and myself. I'm for the bill, and I'm not testifying.
Very good. Thank you so much.
Thank
May
you.
we have your permission to correct the spelling of your name as you've indicated?
Please do.
All right, done.
Thank
Thank
you.
you so much. Anyone else wishing to come forward to testify for, on, or against House Bill 4020-4020? There being none, we are now closing the public testimony for House Bill 4020 and recognize Representative Howard to close on the bill.
Thank you, Chairman and members. We're certainly willing to have any discussion about how we can make the time frame work better here. I know that HHSC is here if you need to talk to the commission about how this would be implemented, but the purpose, as you have heard, is just to make sure that the inmates are not only signed up, but actually enrolled in those programs that they're eligible for, so that when they're released, they can get into the programs in their own particular communities and continue to get the health care they need, which will hopefully help them become more productive members of their community. So I can answer any other questions or close.
Questions, members? Thank you.
Thank you. I close.
Oh. 220. Yeah, hold on.
If there's no objection, the chair moves that House Bill 4020 be left pending. There being no objection, House Bill 4020 is left pending. Chair now lays out House Bill 2201. I recognize Representative Canales to explain the bill.
Thank you, Chairman. Vice Chairman Casal. 2201 clarifies statutes so the Texas Department of Criminal Justice will be able to better manage inmate housing assignments. This bill would no longer require state jail felons and other felons to be housed in separated housing areas. Currently, TDCJ, these two groups eat together, they do rec together, they take schooling together, but although staffing's improved since the 15% salary increase on correctional officers was implemented, staffing remains the agency's utmost significant challenge. The judicial system is also beginning to operate at pre-pandemic levels, resulting in about 1,000 inmates a month being sent to TDCJ. As available capacity decreases, the agency would like greater flexibility in utilizing beds. There's no questions. I believe there's a resource witness. This is a common sense bill. These people are already doing every single thing together, but we've got some huge challenges when it comes to our correctional facilities, and this would alleviate some of the problems that we have by creating flexibility.
All right, any questions, members? If not, let the record reflect that Representative Canales has reserved the right to close on House Bill 2201. We now open up the public testimony for House Bill 2201. Is there anyone that wishes to come forward to testify for or against House Bill 2201? There being none, we will now close the public testimony for House Bill 2201 and recognize Representative Canales to close on the matter.
Thank you, Chairman. I would respectfully ask that this be passed out of committee and, if possible, sent to local and consent. This is something the agency needs.
Very good. Thank you. Any questions, members? There being none, this time, if there's no objection, the chair will will move House Bill 2201 be left pending in committee. There being no objection, House Bill 2201 is left pending in committee. Chair lays out House Bill 4362 and recognizes Representative Ann Johnson to explain the measure.
Good morning, Mr. Chairman, members of the committee. What this bill seeks to address are the millions of Texans who face some form of criminal record that trigger other legal prohibitions and diminishes their opportunity with little consequence for public safety. Having the stain of some convictions or petition or deferred adjudications keep them from getting secure housing or seeking an employment, and results in about the loss of $32 billion in lost wages for these individuals. Moreover, under Texas law, eligibility to have one's record sealed is extremely limited. Record sealings or orders of non-disclosure prevents a record from being viewed by private employees and landlords while still allowing law enforcement or other government agencies to access the records. With limited exceptions, only people who successfully complete deferred adjudication for first-time misdemeanor offenses are eligible to seal their records. These restrictions limit people's opportunity to reintegrate into society. I apologize. And what this bill would do would expand the order of non-disclosure for people of non-violent criminal convictions and reduce the amount of time people have to wait to seal certain records. I do believe we have a couple of witnesses on the bill, and I would reserve my right to close.
All right, any questions, members? There being none, thank you. The chair recognizes that Representative Johnson has reserved the right to close on House Bill 4362. The chair at this time opens up public testimony for House Bill 4362. Maggie Luna? She'll be shown for the bill but not testifying. Sarah Mae Jennings.
Good morning.
Good morning.
My name's Sarah Mae Jennings. I'm here this morning testifying on behalf of myself and the Texas Fair Defense Project in support of House Bill 4362.
Very good. Please proceed.
Thank you. I'm the interim co-executive director and policy director at the Texas Fair Defense Project, here today to express our strong support for this bill, which would expand record sealing eligibility to Texans who have completed their sentence and are seeking a better life for themselves and their families. 1 in 3 Americans has a criminal record, including millions of Texans. Individuals with records face lifelong barriers to employment, housing, public assistance, educational opportunities, and more. Studies show that 1 year after a record has been cleared, people are 11% more likely to be employed and earn 22% higher wages. That means thriving families, safer communities, and fewer taxpayer dollars spent on unemployment benefits and other public assistance. I'm an attorney who has counseled hundreds of Texans on their criminal record clearing eligibility in Texas law. In Texas, we have 2 types of record clearing for adult criminal records: expunctions and nondisclosures. This bill seeks to expand eligibility for orders of nondisclosure, which, as explained by Representative Johnson, seals a record or portion of the record from the general public while remaining available to sensitive fields, including all courts and law enforcement agencies. Record sealing availability is extremely limited in Texas. Individuals cannot even petition a court to ask if it would be in the interest of justice to grant the individual and their specific records nondisclosure relief. This bill would simply allow for individuals to ask for the records to be sealed. A judge would still have the discretion to deny nondisclosure relief if it is against the interest of justice. This bill would do 3 things to provide more Texans the opportunity to request nondisclosure relief so that they can better provide for themselves and their families. First, it would reduce wait periods following successful completion of deferred adjudication. Second, it would allow an individual to seal more than 1 misdemeanor conviction. And third, it would expand eligibility to some nonviolent state jail felony convictions. House Bill 4362 offers Texas a clean slate by expanding nondisclosure eligibility, allowing more Texans to access improved employment and housing opportunities for themselves and their families. I urge you to please support this bill, as it would be a huge step for equity and workforce development in Texas. Thank you.
All right, thank you so much. Any questions, members? There being none, thank you so much for your testimony.
Thank you.
Chair at this time calls Sybil. I apologize in advance if I mispronounced someone's name.
Good morning.
Hello, good morning.
My name is Sybil Sabil, and I'm representing Crime Survivors for Safety and Justice and myself, and I am testifying in support of House Bill 4362.
Please proceed.
Crime Survivors CSSJ is a national network of crime victims joining together to share our stories, create healing communities, and advocate for change. We are a flagship project of the Alliance for Safety and Justice. I am a survivor of crime, but also a person living with a criminal history. I have been a role model, tax-paying citizen for over 21 years, but I still face the consequences of my past. While I am fortunate to have a good job, that has not always been easy, and I still can't rent a place to live on my own. At 58 years old, I can't build credit to help buy a house because all of my rental history must be under someone else's name. We deserve to be able to be full citizens at some point, and this bill is a good next step. While it would not apply to me, it would apply to over 5 million others and allow them to fully rebuild their lives and increase their chances of success. I urge you that you vote in favor of House Bill 4362.
Any questions, members? Thank you.
Thank you.
Cole Meyer.
Hello.
Hello, good morning.
Hi. Okay, I'm Cole Meyer. I am a policy associate with Texas Appleseed's Criminal Justice Project, and I am for the bill.
All right, please proceed.
Okay. So as I said, I'm a policy associate with Texas Appleseed's Criminal Justice Project. Our organization is dedicated to changing unjust laws and supporting policies that are data-driven, safe, and efficient. Today, I'd like to discuss the value of and need for expanding record sealing eligibility in Texas. Access to record sealing in Texas is quite restrictive, and these narrow eligibility requirements allow very few people to actually obtain relief. That said, this legislation would produce a plethora of benefits for our state. First, research shows that employment is foundational to rehabilitation. When you are gainfully employed, You are better able to provide for yourself and your family, and thus less likely to engage in recidivating behaviors to make ends meet. Expanding record-sealing opportunities would promote financial stability for more Texans, which subsequently reduces crime and stimulates the economy. This would also have a downstream effect on our court system, where our courts would save money and time if less people are reoffending. Additionally, record sealing promotes public safety in our communities. Multiple studies have shown that those who are able to get their records sealed commit crimes at a rate lower than the general population. Simply put, public safety is better served when people have a second chance to thrive and succeed without the barrier of a criminal record. I also want to highlight that Texans of all stripes express strong support for second chances. A Clean Slate Texas poll in November of 2022 found that 2/3 of Texans believe our state should remove barriers to unemployment, housing, and education to those with criminal records post-pandemic, with a majority of all partisan groups agreeing. 84% of Texans supported the notion that everyone convicted of a crime deserves a second chance once they've completed their sentence and have shown they're not a threat. Additionally, 2/3 of Texas voters support automatically sealing the records of those convicted of misdemeanors and low-level felonies, so those records cannot be accessed by employers and landlords. So while we can hold somebody accountable for the mistakes they've made, we can also allow for restoration and second chances, and the data encourages us to do so. To close, record sealing is an effective way to provide second chances to those who've completed their sentence and remained crime-free. This bill would allow more Texans to get back to work and support their families. It would maximize public safety and also stimulate our economy. I urge you to support this bill, and we'll take any questions that you have.
All right, thank you, Mr. Meyer. Questions? Thank you so much.
Okay, thanks.
Kevin Tarver?
Good morning.
Good morning, sir.
My name is Kevin Tarver, and I'm representing crime survivors for safety and justice. And myself and I am testifying in support of House Bill 4362.
Please proceed, sir. Go ahead.
All right. And as victims, what we want most is for what happened to us never to happen to anybody else. But I have family, I have friends in my role in the community. I've seen so many community people that has went through not only what my family's went through, but what I've seen friends go through. And it would have been impacted by this bill. And I saw them struggle to gain and maintain good employment because of being system impacted, while on supervision, they couldn't find jobs that would even pay enough to even live and pay their bills. And then after their sentences were completed, their records kept them from finding better employment, even when they were sometimes overqualified from credentials that they have obtained. And the inability to find stable employment often contributed to a cycle that led to more trouble. I support allowing more people to seal the records to increase their opportunities at housing and employment. And as crime victims in communities most impacted by crime and violence need investments in healing, rehabilitation, trauma recovery services, and mental health support to stop the cycles of crime and make our communities even safer. Crime Survivors for Safety and Justice believes that crime survivors must be at the center of conversations on public safety and the justice system. And as crime victims, we have often felt unseen, but we need a balanced and accountable justice system that prioritizes healing, prevention, and recovery over incarceration. And thank you for hearing this bill and the opportunity to speak. And I can answer any questions if you have them.
Thank you, Mr. Tarver. Members, any questions? None. Thank you so much. Which one? Chair calls Tara Tucker.
Good morning. My name is Tara Tucker, and I'm the Texas State Director for Alliance for Safety and Justice. I am also testifying in support of House Bill 4362. Thank you, Representative Johnson, for authoring this important legislation, and thank you, Chair and Committee, for hearing it. The Alliance for Safety and Justice is a multi-state organization that aims to advance public safety priorities that stop cycles of crime, increase trauma recovery services, and promote successful re-entry in states across the country. We know millions of Texans have criminal records that keep them from achieving economic stability. In most cases, despite having served their sentences, the criminal record follows them for the rest of their life. Old records should not be a lifetime sentence to poverty, and we can change that by expanding access to petition-based record sealing. I'm not gonna walk through each step of this bill again because that's been done. But I think we've worked with the office to try and make sure that this applies to multiple types of situations that maintain public safety and expand people's opportunity to better support themselves and reintegrate into their communities. We know that economic stability equals safety, so clearing a pathway to meaningful work for people with records is necessary to help with our workforce issues, reduce recidivism, and ultimately make us all safer. And again, this is petition-based and fully discretional. So a judge gets to look at every single one of these and make a determination about whether or not this is in the best interest of justice and the best for our community. So I ask for your support, and I am willing and happy to answer any questions you might have.
Are there any questions, members? Thank you so much. Maggie Luna?
Hello, Chair Herrero, members. Thank you so much. Sorry I was not here when you called me. My name is Maggie Luna, and I am representing the Statewide Leadership Council, and I'm in favor of House Bill 4362. And
Just real quick. Maggie, you're showing up as Maggie Luna. So obviously your name is Maggie Luna.
Yes.
Do we have your permission to remove one of the the Maggie Lunas
Please.
listed? Thank you. All right, please proceed.
I must have been excited.
Go ahead.
So I don't want to repeat everything that's already been said. I am formerly incarcerated, and I believe that if this bill was in effect when I first started in the criminal legal system, it might have deterred me from going back in and out, because once I first had my first probation, I knew that nothing was I was going to have to put this on my applications for the rest of my life. And it seemed really overwhelming at that time, and it was easier for me just to continue the life that I was in. And so I believe that this would give people an opportunity to become members of society where they don't continue to cycle in and out of the system. And so 1 in 3 Texans are touched by the legal system. You have either been arrested or know somebody who's been arrested, and this would benefit so many people and stop the cycle and really contribute to community safety. So, thank you.
All right, very good, Maggie. Any questions, members? Thank you so much. Anyone else wishing to come forward to testify for or against House Bill 4362? There being none, Chair will close the testimony for House Bill 4362 and recognize Representative Johnson to close on the measure.
I'm grateful for the witnesses who came to share their stories and support the bill, and I close.
Thank you so much. Any questions, members? Very good, thank you. If there's no objection, House Bill 4362 will be left pending. There being no objections, House Bill 4362 is left pending. Just to give everybody an idea as to kind of where we're heading with this, we're going to take up Reggie Smith's bill, Representative Moody, and then I know Representative Mesa was here. I let her know that there are a good number of witnesses for Representative Moody's bill. So just to give people an idea as to when they may come up. So at this time, the chair will lay out House Bill 2743 and recognize Representative Smith to explain the bill.
Thank you, Chairman. Vice Chair, Mr. Clerk, and members. It is reported that there has been a 38% increase in the number of people found incompetent to stand trial in Texas over the past 2 decades. In September 2021, 1,766 people were waiting in jail for a state hospital bed. In September 2022, that number had reached a record 2,540. This means that a defendant has to stay in our local jails waiting for the chance to go to the state hospital to receive competency restoration training and treatment. This delay prevents justice being completed for the defendants and for any possible victims. Under Texas law, the competency statute is found in the Code of Criminal Procedure 46B. This bill is seeking to amend that statute. That code currently requires a 2-step process. First, a hearing would have to be held before a probate court. Remember, many counties have non-attorney county judges. And that court would make a determination whether medication should be ordered under a civil standard, and if the order is not granted, there has to be another hearing before the criminal court with heightened standards. This was set up to comply with the U.S. Supreme Court decision Sell versus United States, that a determination has to be made first under the civil standard before considering the criminal standard. However, the current law goes beyond these constitutional requirements and provides unnecessary burdens. This bill, as drafted, and I will just tell you, and I apologize for this, there will be a substitute. I'm not happy with this bill as it's currently done, but I'm going to work quickly, very quickly, to get something to you. The substitute would clarify that the criminal court that is handling the case consider both standards. As required first, it is possible for the order to be compelled under the civil standard, and if not, the same judge having jurisdiction over the criminal case would determine if the criminal standard would be met. It makes sense that the judge that ordered a competency evaluation to be performed received the report from the examiner and held a hearing and determined incompetency to also be the judge that deals with this case. Note that sometimes a judge in a particular jurisdiction may handle a specialized competency docket, so they may not have been the one that determined incompetency. For larger jurisdictions that are currently successfully using the current system, this bill would not prohibit them from continuing to use the current method. Additionally, the requirement to have 2 physicians to file a CME for a criminal court evaluation would be removed. This is often costly and problematic in mid to small size counties to find or afford a doctor with the experience or inclination even to get involved. Also, this is not required by the constitutional law. The effect of this is that defendants that could otherwise have their competency be restored have to wait in jail until the state hospital bed becomes open. Thank you for your consideration. Reserve the right to close and be glad to answer any questions that you have.
Any questions, members? Thank you so much. The chair recognizes that Representative Smith has reserved the right to close on House Bill 2743, and at this time the chair opens up public testimony for House Bill 2743. Adam Haynes.
Mr. Chairman, members, Adam Haynes with the Conference of Urban Counties, and I am here to support Chairman Smith's bill. I want to thank him for bringing yet a great bill. And again, Mr. Chairman, thank you for hearing yet another great bill for counties. This bill, all it does, you may hear testimony, unconstitutional. I'm not an attorney, but we've had plenty of folks that have, our county attorneys looked at this. This bill is a continuation of CARE bill. It allows our folks in the jail to continue a doctor's orders and make sure that the patient, in this case a detainee, is on a continuation of care. That's all this bill does. It allows us to keep that person with the psychotropic drugs that were prescribed by a doctor, generally developed and then put forward in a confinement setting by a nurse practitioner, and then delivered by a tech. It's the same exact situation that you see in any state hospital facility or any state facility in many private facilities. The doctor's orders are carried out by a nurse or a nurse practitioner and then delivered by a tech. That's exactly what we do in the jail setting, and Chairman Smith's bill will allow that continuation of care to go forward for the detainee so that they maintain competency, and then that criminal justice is it then proceeds on a faster track than otherwise would if the person doesn't receive the medication that's prescribed by the doctor. With that, I'm happy to answer any questions.
Any questions? Thank you.
Thank you.
Anyone else wishing to come forward to testify for, on, or against House Bill 2743? There being none, at this time, the chair will close public testimony on House Bill 2743 and recognize Representative Smith to close on the bill.
Thank you, Chairman. I really look forward to getting you a bill that more closely mirrors what I'm trying to accomplish here. But I do think, particularly in rural Texas, we have a little bit of an emergency on this. We've got folks in, for instance, in one county, my smallest county, Delta County, is 5,000 people in Delta County. There's an old boy sitting over there in jail that's been there for a year. And it's because we can't get into a state hospital, but if we were able to provide him humanely in accordance with the standard of care, the medication he needs, maybe that hurries it up for him. And so there's folks like that all over the state, and I think this bill tries to address that, and I appreciate it.
Yeah, you're welcome. Any questions, members? There being none, this time, if there's no objection, House Bill 2743 will be left pending. There being no objection, House Bill 2743 is left pending. Chair, at this time, will lay out House Bill 1618 and recognize Representative Moody to explain the bill.
Good morning, Mr. Chairman. Please excuse me, my allergies are acting up this morning. Love this time of year in Austin. The dry climate is much better for me. At any rate, incentives are something that we talk about a lot in this building, and we can't force the business market to take a certain shape or create certain outcomes for our public school students just by waving a magic wand, for example. But what we can do is reward the things we want to see and put systems in place that make those results achievable. It's no different for our prison system. When we lock people up, part of that is to punish them. But it's also for rehabilitation. I think we all know that's an area we sometimes fall short in, which is something that House Bill 1618 tries to address. One of the main carrots we have in corrections is good time credit. Prisoners have a chance under current law to earn their freedom faster for good behavior and for doing certain things like work and education. One thing we wrongly exclude is seeking treatment. If our goal is to send prisoners out into the world better than when they came in, with more tools and more effective mindset for staying out of trouble, then we need to incentivize appropriate treatment everywhere that we can. So House Bill 1618 adds treatment program participation to the list of things that award good time credit. The other issue it addresses is many of the situations where a person can't earn good time towards release. Under current law, certain offenses mean we don't even consider good time, which doesn't make a lot of sense, in my opinion. The parole board isn't required to parole anyone. It's just parole consideration. So why not give as many people as possible a reason to behave, work, and better themselves, then let the board do its job and let them decide who's fit for parole or not. The bill does not change, the bill does that and also clarifies some language around good conduct time in county jail before transfer to prison to make sure that people get credit for the time that they've earned. Again, it's a simple matter of incentives. This bill doesn't get anyone out of prison. That is up to the board, as it always has been. But it does give people the motivation to be better with the promise of at least an opportunity for a parole review. Members, I'm happy to answer any questions and, if appropriate, be recognized to close at the end of testimony.
All right, very good. Any questions, members? There being none, at this time the chair will recognize that Representative Moody has reserved the right to close on House Bill 1618 and open up public testimony on House Bill 1618. Chair, at this time will call Diana Brizeno.
Hi, everybody. My name is Diana Briseño, and I'm here in support of House Bill 1618 and the duplicate bill. It's not up yet, but 1064. And so I am in support of the bill. I am here in support of the bill.
So what I need to know,
I'm sorry.
it's okay. Take your time, take a deep breath. There's no rush, and we're here to listen. So I show that you listed TIFA and UT Health Houston.
Yes.
And yourself, obviously. And then that you're, let me see, a licensed social worker and licensed chemical dependency counselor.
Yes, sir.
And then you're for House Bill 1618, is that correct?
Yes, sir.
All right. So then please proceed and let us know what you think is most important to know.
Okay, and I'm a little nervous.
That's okay.
Why? Okay, so my name is Diana Briseño. I am writing in support of House Bill 1064 and 1618 relating to good conduct time to certain inmates.
Let me make a point, and I apologize for not making this clearer. Even though we may have bills that are identical, if
Yes.
we only call one bill up and then we call your name to testify with respect to that bill,
Yes, sir.
I need you to make sure, everyone, to stay only on that bill.
Okay.
And then we'll bring up that other bill another time. So it's real important for us to make sure we have a clear record and minutes, if you will, as to what is happening. So right now, we are on House Bill 1618 by Representative Moody. So as to that bill, what can you tell us?
Yes, sir. So I am in support of House Bill 1618. Thank you, Mr. Moody, for authoring the bill. My son was incarcerated when he was 18. He received a 50-year sentence. My son was diagnosed with depression, anxiety, and substance use. Depression, anxiety at age 12, and substance use at age 14. At the age of 18, he wasn't arrested. My son was very young, not able, was very immature. Since he's been there, he has grown, he has matured, he's doing very well. He graduated from the faith-based dorm. He works in the chaplain's office. He's completed many programs that I've listed here. The Kairos program, purpose-driven life, cognitive intervention, rational behavioral therapy, brother-to-brother, authentic manhood, winning at work and home, just so many, a leadership class called the Toastmasters. And he just does his best to have, even though he's incarcerated, he does his best to have a positive outlook on life. So House Bill 1618 would give me and many family members the opportunity and the hope to be able to have that hope for our sons and daughters, friends, to be able to have their good conduct time reviewed and considered when at a sooner time when they can come up for parole. Yes, I am a social worker, and I've tried, I work in the opioid pandemic, everything that's happening right now with the opioids. And so I try to help people, and I just really want to be able to help those that are incarcerated, many who are incarcerated because of mental health and substance use. And so I think I'll stop there. Thank you so much.
You're welcome. Ms. Briseño, I have a question. Do you believe that this bill would help your son?
Yes, sir. Yes, sir. He receives a timesheet every year that says he has good time, and if it were true that he had that good time, he would have already been able to be up for parole. But he receives the timesheet, but it's not really true for him. He has to complete 25 years before he has parole for the first time. But he's doing very well, and if he were to have that chance, it would of course be up to the parole board to make that decision. But his progress would be able to be considered and reviewed. So. Thank you so much.
I'm curious. Well, never mind. I'll follow up with you on another matter, if I may.
Yes, sir.
All right. Thank you so much.
Thank you.
Christina Moore.
Just thought it'd make her feel good.
Go ahead, Ms. Moore.
Good morning. My name's Christina Moore, and I am against House Bill 1618.
And you're here representing yourself? Is that correct? Because that's how you're registered.
Yes.
Okay.
Yes. I was told by law enforcement and the court system that the guy who murdered my sister would stay in prison for at least the minimum of 30 years before he was up for parole. And me and other victims were promised that the people that murdered their family members would have a minimal time of, whatever their sentence was, half of the sentence, and mine would be for 30 years. So if this bill is passed, then the guy that murdered my sister will be able to get out of, jail within this year instead of serving 10 more years. But he got a life sentence. So I expect to get what I was promised, and so do other victims. And I'm here to represent myself and my sister that was violently murdered. She was only 25, and I expect the guy that killed her to stay in prison at least another 10 years, and actually for the full life sentence that was promised to us that he would serve. So I represent myself.
Understood. Any questions, members? There being none, if you could give us a quick minute, Ms. Moore, we're trying to check something real quick.
Yes, sir.
All right. Thank you, Ms. Moore. I appreciate it.
Thank you.
Thank you. Rhonda Kirkendall?
Chairman Herrero, committee members, thank you for the opportunity to talk to you this morning. My name is Rhonda Kirkendall. I am here in opposition to House Bill 1618, and I am representing myself. I serve on the Texas Human Trafficking Survivor Leader Council. I chair the Fort Bend County District Attorney's Human Trafficking Team. I chair the Legislative Advocacy Team for Child Advocates of Fort Bend, and I also work as the Anti-Child Trafficking Consultant to Texas CASA. I am a survivor of human trafficking. On my way over this morning from Fort Bend County, I was on the phone with the El Paso Parole Office. An arrest warrant has been issued on a 4-time convicted child sex offender. He is my trafficker, and I was 10 years old when I was trafficked. I received the text message on Friday at 3:32, but I didn't read it then. I was out wedding dress shopping with my daughter. She's a high school algebra teacher in Dallas. So we sat down to dinner, and the text message came in, and I read it. My daughter immediately asked me, "Mom, what's wrong?" So my mind was racing, and I didn't want to steal this moment from my daughter. And so I kept it from her, and I didn't tell her what was going on. But in the back of my head, I began wondering, what did he do? Am I safe? He's not in custody yet. And so that is the life of a victim with a perpetrator that is eligible for parole or on parole. My trafficker, this isn't the first time he's been revoked. He was revoked in 2008 for misuse of the internet, which is just a minor parole violation. He was revoked, which made him eligible for parole every single year. So every single year for 10 years, I fought him from being released. And I did it. And what that means for a victim, it means that for 6 months out of every year, I felt safe. I knew where he was. The other 6 months of the year, I was notified by TDCJ that he was up for parole, and I had to go through that process and wait. I do believe in restorative resources for inmates. I have worked several years for Bridges to Life, going into the prison systems and working directly one-on-one with inmates. But there is a fine balance. This balance means that it cannot sacrifice victims and their rights, and that's what this bill does. Violent offenders are up for parole when they serve 50% of their sentence. Through lived experience, I know how difficult that already is. And I don't testify out of anger, retribution, but I know firsthand that while we are freeing these perpetrators, we're giving victims and their families a life sentence. Victims need time to heal without the fear of the perpetrator being released. And with that, I open it up for any questions.
Any questions, members? Thank you so much for being here and making time. Thank you. Chair will call Andy Kahn. Oh, before you start, I'm sorry. Let the record reflect that Representative Swanson is present. Go ahead.
Thank you. My name's Andy Kahn. I'm Director of Victim Services for Crime Stoppers of Houston. Thank you, Chairman, for allowing us to testify. I'm here against House Bill 1618. As a victim advocate for over 30 years and a board member of Parents of Murdered Children and Surviving Family Members of Homicide, I can unequivocally tell you the repercussions and damage this would have on the clientele that I work with regarding parole eligibility. According to the Texas Department of Criminal Justice, if this bill were to pass, over 5,000 violent offenders, 5,000 over, would be immediately eligible for parole. This includes murderers, sex offenders, armed robbers, human traffickers, and the gamut of all violent offenders. Eventually, over 38,000 of the above would eventually have their parole eligibility bumped way ahead of what was the original sentence was meant to be. I work with families, and a majority of sentences are plea deals, over 90%. When I speak with a family and I tell them to accept a plea deal of, let's say, 40 years for murder, I knowingly tell this family, at least for 20 years, you are not going to have to worry about that offender coming up for release, because current statute mandates they must serve at least half of their sentence without good time credits. Current statutes are a contract. The families have entered a contract with the defense, with the prosecutors, with the offender. The offender knows full well when they agree to a plea deal what exactly is going to happen. There's no one that's amiss as to what's going to happen. They know if they get sentenced to 30, 40, 50 years, they're going to have to serve half of their sentence. So this is a contract that is established between all parties. This bill essentially would nullify a contract and frankly make advocates like myself appear to be untruthful when we're telling our families that we serve what exactly a sentence means. And I'll give you a great example. Paul Castro's son, David, was murdered in what became known as the Houston Astros road rage murder. The entire community of Houston and Harris County was galvanized after David was murdered leaving an Astros game and sought justice for the Castro family. The offender was eventually apprehended, thanks to a Crime Stoppers tip. A little plug for us right there. When the plea deal was accepted by all parties, including the victim's family and the offender, it was for 30 years for murder. Paul Castro was told he would have to serve 15 calendar years without good time before he would be eligible for parole. I'm asking this committee to keep that promise that was made to Paul Castro's and all the Paul Castros of the state when they agreed to that remains into effect. I wholeheartedly am against this bill, and let's keep the contract, the promise that we made to victims of violent crime and not break the trust that they have in the state of Texas. Thank you.
Thank you, Mr. Khan. Any questions, members? Thank you so much. Charlie Malov.
Morning, morning, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Charlie Maloff. I'm representing myself. I'm the acting vice president representing Texas Cure. Additionally, I'm formerly incarcerated, and we are for 1618. Thank you. Aside from punishment, rehabilitation of the inmate to become a productive member of society upon release is an integral and important process in the effective prison management and a justice-impacted society. Many inmates have only committed one crime. While some of these may be heinous by the nature of the act and the sentence lengthy, the inmate very well may be extremely remorseful and be fully aware of how bad they messed up. Most people do change as they get older, some for the good and some for the bad, but prison should not define a person's ability to want to change for good. Privileges are earned. Regardless of the crime, provided the punishment is neither death or life without parole, every prisoner should be given the opportunity to earn good time credit for demonstrating good behavior and diligent participation in rehabilitative programs. Bad behavior opens the door for loss of other privileges, such as commissary, phone, or visitation, and in some cases, loss of parole. The same loss would be the same with this bill. Any good conduct time earned becomes forfeited with a major disciplinary case. However, for those who try and earn it, this bill provides an incentive for privilege of early consideration for parole as reward. Consideration is the key word. Even for those with lengthy sentences, ongoing credit adds up. Ultimately, it is the parole board that makes the final decision on release other than discharge. One of the relevant factors in the parole decision is what has the inmate done while incarcerated to demonstrate his or her ability to become a productive member of society upon release. To earn these good time credits, one has to demonstrate both good behavior and a desire to program. Ongoing accrual of the good conduct time is a positive demonstration of the inmate's commitment to be that better person on release. This bill is smart justice and in the interest of justice, and we thank you for the opportunity to support this bill.
Thank you, Charlie. Any questions, members? Thank you for your testimony. Jennifer Yo?
It's Jennifer Yao.
Yao, okay. I was one of two options in
No,
my
that's
mind,
okay.
so
That's fine.
apologize.
Hey, I'm getting used to it now because it's a new name. So, yeah.
All right, please proceed.
Thank you so much. My name's Jennifer Yao, and I am in support of HB 10. Oh, I'm sorry, I'm 1064. I'm 1618 on both. The earned time credit bill.
And you're here representing?
And I'm here representing actually myself.
Perfect. Please proceed.
I am actually a survivor, victim of violent crime. My children and I were victims of a violent crime at the hands of a family member in 2009. And for me to say that I'm standing here today is from the grace of God, because the three of us should be dead right now. But I am actually in support of this bill as a survivor of victim of violent crime because of the fact of I found forgiveness of my offender. I was able to walk into a Texas prison in January of 2015 and face my offender face to face with no malice, with no anger and bitterness, and talk with him and forgive him and be able to move on with my life. And that was the only way that I could move on with my life and for my children. And since then, I've been doing prison ministry, and I've been in the prisons. I've done all different kinds of things, and I've met so many men and women who have worked so hard to change their lives. They are remorseful for what they've done. They take responsibility for what they've done. And I feel like that we need to look at the whole person, not just the offense. We need to look at a changed life. And I liked how Moody talked about public education. I've been a public education school teacher for almost 30 years. And when my students come into the classroom and they work hard, I give them a reward. They get some kind of earned credit. They get some kind of credit for doing what's good and what's right. And I think that in the prison system, it's the exact same way. I've met so many men and women in there who have gone to college, who have a college degree, as my husband does now. He is a field minister. There are people in there who are doing transition programs, substance abuse programs, teaching, all kinds of things. They're doing so much to make a positive change in society. So let's give them that chance to come out and give hope to their families, to give hope to single parents who are, give hope to them. It's not just the hope for the people that are in there. It's the hope for us as families. It's the hope for the children that they will be able to see their parent come home, or children, and that's what's most important to me, is that, I stand up here as a survivor, and, people say to me, Jennifer, how could you come up here? How could you come and support this bill when you were a victim of crime and that you and your children should be dead right now? I can because of the grace of God, and I can because there is forgiveness, and I can because I just feel that people need to be restored, and people can be restored. And that, we talk a lot about rehabilitation, and I hear that all the time, and I'm new to the whole TDCJ, this and that. We talk about rehabilitation, but I know that there are people in there that are working hard to rehabilitate themselves, and I feel that they need some earned credit for that. So I'm in support of this bill.
Well, thank you, Ms. Yeo, and thank you for for being a school teacher. I appreciate that.
Appreciate that
a great deal, and then for your strength and your courage, and for sharing your personal story with us. So
thank you.
I thank you.
I appreciate that.
Any questions, members? Oh, yeah. Thank you so much.
Thank you so much.
Let the record reflect that Representative Sherman is present. Anyone else wishing to come forward to testify for, on, or against House Bill 1618? Hearing none, public testimony now is closed on House Bill 1618. Chair recognizes Representative Moody to close on the bill.
Thank you, Mr. Chairman. And I certainly appreciate everybody's testimony. As someone who served as prosecutor for some time, representing victims' voices in the courtroom, it is not lost on me the importance of them in this conversation. I was often say that the struggle for us in this arena is finding the proper intersection between justice and mercy. Where that lands is our challenge and what we should always strive towards. Maybe this bill is it, maybe it isn't. Now, I'll tell you that the witnesses that came and testified against it, we're talking about one specific portion of the bill, not the bill in its entirety. And so I think that's something to consider as well. Maybe this hits that right intersection and maybe it doesn't, but it is absolutely worthy of conversation. And so that's why I appreciate you, Mr. Chairman, for setting it for a hearing, because it's something that we're going to continue to discuss. I will say that as someone who has dealt with the Board of Pardons and Paroles for years now, their decision making is thorough. It is one that I think they take very seriously and weigh all the options in front of them, as well as take all voices into consideration. So their decision making wouldn't be interrupted under any of the terms of this bill. If there's no questions, I'm happy to close at this time.
Any questions, members? Thank you, Representative Moody.
Thank you, Mr. Chairman.
Thank you. If there's no objection, the chair will leave House Bill 1618 pending. There being no objection, House Bill 1618 is left pending. Chair now will lay out House Bill 812 and recognize Representative Mesa to explain the bill.
Thank you, Chairman. Committee members, for hearing this bill. This bill is about solitary confinement, sometimes referred as administrative segregation, sometimes called restrictive housing. Whatever name you use, the length of time that we keep people in there, it should be considered inhumane treatment. I don't know if you knew, but on the day that we started our house on January 10th, we were doing our opening day and celebrating and our swearing in. Prisoners throughout Texas went on a hunger strike protesting their imprisonment in solitary confinement. And it went on for days and weeks. Of course, as each days and weeks passed, there were fewer and fewer still on it. As you might imagine, they lost a lot of weight. But protesting what they felt was their inhumane treatment of solitary confinement. This bill doesn't aim to end solitary confinement, but it does aim to put a limit on it, maximum of 10 days. That's when inmates isolated from the rest of the prison population. Texas is leading in a place where I don't think we want to be leading, and that is in the use of restrictive housing. 3,141 inmates as of November 2022, holding more prisoners in prolonged solitude than all other states combined. This practice is shown to have detrimental effects on mental health and can increase recidivism rates. I don't know about you, but I don't know how long I could stay in solitary confinement. I think if one of our elevators got stuck, that would be a problem for me. But they say, the studies say, and I don't know that we need a study, but I guess it's important to know there have been studies. Studies say that anything more than 7 days has irreparable mental damage. And some say 15 days is the amount of days that should be the maximum. So this bill kind of cuts that in the middle and says maximum of 10 days. It has an effect on an individual's mental health, anxiety, depression, hallucinations, even suicidal thoughts. So by limiting it to 10 days, we can mitigate these negative effects and ensure that incarcerated individuals are not subject to prolonged psychological harm. Secondly, the research indicated that prolonged isolation can hinder rehabilitation efforts and increase the likelihood of recidivism. By limiting the use of solitary confinement to 10 days, we can prioritize rehabilitation and reduce the likelihood of future offenses. When one of my constituents called and told me that her husband was in solitary confinement, my knowledge of solitary confinement was just basically from TV shows and movies. I thought of it almost like more strict, of course, than a timeout. Like if someone had gotten in a fight in the prison, then they would put them in solitary confinement. That I thought they would stay there for days. Kind of like think about what you did, learn your lesson, don't do that again, and that they let them back out. But no, when they put them in solitary confinement, people aren't in there just for days or even weeks, but months, years, and there are people that have been in there for decades in solitary confinement. So when I learned that was the impetus toward this bill, that's just way too long. It costs up to 3 times as much as housing an individual in the general population. Limiting the use of restrictive housing would help reduce costs and be more physically responsible, if you want to look at it from that perspective. It's an expensive practice. It hinders rehabilitation efforts. I think I skipped down on my notes. It hinders rehabilitation efforts because how do we expect a person to function well in society when they're released if they've been in solitary confinement for decades without very little human contact? And yet we want to put them back in society. And whether you like it or we like it or not, most prisoners are going to come back into society with us. And they're going to be living in our homes, and not our homes, our hometowns and our neighborhoods and so on. And to have to put somebody back into society who has not had contact with people much for decades, how are we expecting them to function well? It's been criticized by international human rights organizations as a form of cruel and inhumane punishment, and limiting the use of solitary confinement to 10 days would help ensure that Texas upholds its commitment to human rights. In conclusion, HB 812 is an important piece of legislation that seeks to limit the use of restrictive housing in Texas prisons. So I urge the committee to consider the detrimental effects of prolonged isolation on mental health, on our efforts to rehabilitate prisoners, the effect it has on the cost, how expensive it is, and the effect it has on human rights. And I hope that you'll support this bill. Thank you for your consideration. I believe you might have some witnesses here, and I reserve my right to close.
Any questions, members? If not, let the record reflect that Representative Mesa has reserved the right to close. Chair, at this time, will open up public testimony on House Bill 812. Dr. Dominic?
Hi, my name is Dr. Amit Dominic, and I'm representing Texas Prisons Community Advocates, and I'm in favor of this bill.
And yourself as well, correct?
Yes,
Dr. Dominic?
myself as well.
All right, please proceed.
And I'm reinventing my testimony since Representative Mesa laid this bill out so well. I have something from an incarcerated individual, one of the ones who went on the hunger strike. He says, I noticed that also my loved ones have noticed that during visits, when I'm able to face-to-face conversations with someone, I look everywhere but at them, at their eyes. I'm currently... This condition I'm currently in, I don't need to. It affects me mentally because it plays on my self-confidence. I notice now that I tend to be anxious when I'm face-to-face, trying to have a conversation or trying to get something done because of being deprived of a basic need.
explaining that, I think to myself, how do I expect to have a successful job interview, much less hold a job, be a productive member of society? I can't even perform the basic functions now. I've noticed that my short-term memory is slipping. This environment, I'm not really expected to perform any type of cognitive function or activity that forces me to use any type of cognitive skills. Plus, this has desensitized me to so many things visually, physically, and emotionally. I feel like I'm just a living shell with no substance, if that makes any sense. What's not present in these kind of conditions is rehabilitation. And one of the things that this system boasts on is that we're supposed to rehabilitate these individuals who are incarcerated. But instead, we're doing the exact opposite by leaving them in these conditions of isolations. We wouldn't put an animal in that kind of a cage for 22 hours plus a day. We would definitely not do it to our children, definitely not do it to our parents. There is study after study after study from a psychological perspective that indicates what is needful for a healthy individual. We are doing the exact opposite of that by continuing to allow this type of isolation, this type of solitary confinement for these individuals. And to make this, if it could be even worse, it actually has become even worse with the lack of staff that we currently have at TDCJ. It is said that they're supposed to be out an hour a day. That's not happening. I have letters who are telling me they weren't given showers for weeks. They get very sparse meals for weeks. They're not getting to see their loved ones as often as they need to be. And if they do, it's behind a glass. We're not having any physical contact. And if we even go back to the studies on the children in Bosnia, we know that we need physical touch, that these are basic necessities. And then we're releasing these individuals out into society without the necessary programs. This individual goes on to talk about, I just wanted to get a GED, at least. He can't even get that. They can't even get those type of programs. We even have these individuals who went on a hunger strike, just to give you a little perspective of who they are.
Dr. Dominic, I'm sorry, your time is up. Is there something else that you want us to know?
Just this individual and his medical condition. He had diabetes and several other issues, and he stated he'd rather die during the hunger strike, knowing what he was in for. That's it.
Other questions, members? Any? All right, thank you, Doctor. Thank you. I'm going to say this name again, Marsu Simmons. It may seem redundant and petty, but we have to make sure that I read the name as written, and then.
I'll do my thing.
Yes, please. Go ahead.
Yes, sir. My name is Marcy Simmons. The correct spelling is Marci. Apologize for that. I'm here representing myself, Linus Justice Impacted Women's Alliance, Statewide Leadership Council, and I'm in favor of the bill.
And then do we have your permission to change the spelling to
Please
reflect
do, yes,
that
sir.
as it should be?
Please do.
All right, thank you. Please proceed.
Yes, sir. Thank you, Representative Meza, because she did lay out the bill beautifully. I spent 10 years in prison in Texas. I've been home for 2. I knew personally 9 inmates that took their own lives while I was incarcerated. There were more than that, but 9 that I had direct association with, 100% of them were housed in solitary confinement when they took their own life. When Miss Dominic was sharing her testimony, my palms became sweaty and I was having flashbacks of being in solitary confinement. So I'm going to try to get through this quickly, but also give myself a little bit of grace for that. The first time that I was sent to solitary confinement, it was for 34 days. It was during mail call. I was walking back to my cubicle. An older lady was sitting in her floor of her cubicle reading her mail from home, and she was in tears. I stepped into her cubicle 1 foot and hugged the top of her shoulders, which is completely against the rules. It's completely against policy for me to, number 1, stop in front of her cubicle, and number 2, offer any kind of physical contact. I then went to my cubicle. What I didn't know is that they saw that incident on camera. Moments later, maybe 20 minutes later, we hear a bunch of keys coming in, and it's officers and ranking officers, and we're on alert because we know something's going on. Something has happened. I was shocked that they were coming from me, 5 or 6 officers, to handcuff me and take me to solitary confinement for that act. When I went in that building, there's no words to describe the kind of darkness and despair. If you are any type of spiritual person, you know that there's evil in that building. Sadness, desperation. I entered my cell. It was dirty, small. When they closed those doors, it was something to get through just that 34 days. When I learned how long some of the women had been in there, my heart broke for them. During that time, I had a visit. The way visitations go from solitary confinement, when you're housed in solitary confinement, they house you in a gown. So you're in a gown. When you go to visitation, they bring you a jumpsuit. They brought me the only jumpsuits available for me, because laundry was closed on the day of my visitation, was like a 3X jumpsuit. You could see completely through it. I was exposed. I was walked handcuffed, and this is for a hug. Handcuffed to the visitation area. I was put in a little box with the glass. My poor grandmother was sitting on the other side of the box. They closed the door, I'm handcuffed, and I just remember getting down on my knees and making eye contact with my grandmother, who had watched these officers escort me to visitation. And when I was able to sit down and pick up the phone, she said, "What did you do?" She just could only imagine it must have been some kind of horrific act in there for them to do all of that. A few years ago, and I'm sorry that I don't know, there was legislation passed limiting or stopping the 15s, is what we called them, from prison, and that was to use a 15-day as a punishment. What TDCJ then started doing is holding us for investigation for that time. So is my 3 minutes up? Okay. Thank you. Holding us for investigation during that time. So they kind of went around that. So I also asked just for oversight if this bill were to get passed. I'm in contact with a lot of people that are incarcerated through my social media things and through Lioness Justice Women's Impacted Alliance and Statewide Leadership Council. I have one quote from one.
And I'm sorry.
Yes, sir.
I'm going to have to stop you.
Yes, sir.
And we'll follow up with you if we may, please, because I'd like to learn more about your experience, if you will.
Yes, sir.
Let the record reflect that Representative Dr. Allen is present. Any questions, members? Thank you. Appreciate it. John Hernandez.
Good morning.
Good morning.
I want you to know this is the first time in a long time that I've been
No, that's
free.
okay, Mr. Hernandez.
so
Here's what I want to
give me
find out.
some
What's the correct spelling of your first name?
John, J-O-H-N.
J-O-H-N?
Correct.
So it's shown up as different than that. Do we have your permission to be able to
Go ahead.
correct it as you've identified? And then you're here representing yourself, is that correct?
Yes, I am.
And then you're for House Bill 812?
Yes, correct.
All right, let us know what you think is most important, please.
Okay.
Thank you.
Long periods of administrative segregation is wrong. This form of housing only creates a hopelessness in our emotions. This by many. This includes no physical contact with family and friends, slim chances of parole, education, rehabilitation. My personal experience was 37 years, 2 months, 9 hours, 34 in ag sig. This psychological effect of administrative segregation, long-term housing is wrong. It affected me. PTSD was created by my long-term administrative segregation. Some go insane, and many commit suicide or self-medication. To get out of administration, that's what they do. They cut themselves. Create change to practice a system that is on point, because great harm is being done by long-term AgSeg housing. I want to add, say, this housing personally affected me like a monster. I came out, but through God, it changed me entirely. This is being done and it's wrong. And they're hiding behind paperwork. They like masquerade what they painted all up, and some of y'all go visit there. That's all they're doing. They're practicing a practice that's not working. 34 years of it. I want that wrong corrected, please. They're releasing people that haven't even, like me. I'm learning how to use a computer, my cell phone, talking to people, waiting on a bus stop, getting all nervous. Why is nobody concerned about that bill? Releasing people are saying like that? They're gonna go off and do something wrong. Please look into it, pass that.
All right. Thank you, Mr. Hernandez.
Thank
Any
you.
questions, members? Thank you for your time and your testimony, Mr. Hernandez. And I encourage you to come as many times as you would like.
I will, now that I know of this.
How it works and what the process is. Yes, please. This is your capital. Thank you. God bless you. Wolf Sittler.
Good morning. Mr. Chairman, members, my name is Wolf Sittler. I'm here representing a man who was released from solitary confinement last month. Here's his letter.
Yeah, Mr. Sittler, I'm sorry, before you proceed, and you're here representing yourself, is that correct?
Yes.
And you're here for the bill?
I'm for the bill.
All right, please proceed.
Here's the letter. Greetings. My name is Don Aldaco, and I'm asking you to please support HB 812 to limit the use of solitary confinement, administrative segregation, and restrictive housing, which are all the same in TDCJ. I was released from AdSeg on March 13th, 2023, after serving 26 years. And of those 26, I did 24 years flat in solitary confinement for non-disciplinary reasons, just for being tagged as a security threat group member, that's STG, even though I've never committed an STG infraction in TDCJ. I was tagged for an incident that happened in the county jail prior to me coming to TDCJ. I was released straight from the box and into society with a Social Security card and birth certificate, and not even a Texas ID, which should be provided upon release. I was never given an opportunity for any rehabilitation or educational courses. And instead, I did 24 years in a cell praying that I wouldn't go crazy, praying that I wouldn't succumb to the extreme mental health issues some developed and end up taking my own life as others have in the past from this extreme way of housing human beings. I know there are some dangerous individuals in prison, but many in AdSeg are not dangerous, but are there because of a label that got put on them. Why keep us locked up for so long without rehabilitation programming? How much sense does it make to release us into society without preparation? Releasing us into society worse off than when we came in is not what the TDCJ mission is about. My experience tells me that too many are kept far too long in solitary for no good reason. There have to be more effective ways of dealing with people. Hopefully, this bill opens the door to look at how to treat prisoners more fairly and humanely. Our society will benefit when those released from prison are fully prepared. There is so much more that I'd like to share, but know that time is a factor. So please consider my words and my experiences and vote for HB 812. God bless and keep me in your prayers. Thank you.
Very well done, Mr. Settler. Appreciate the submission of testimony. Thank you.
Thank you.
Any questions, members? Thank you. Molly Pachenik.
Thank you for the opportunity to share comments on HB 812. My name is Molly Pachenik, and I'm an attorney at Texas Civil Rights Project. I'm testifying on behalf of Texas Civil Rights Project in support of HB 812.
All right, please proceed.
We strongly support this bill and the sensible limits that it places on the use of administrative segregation in TDCJ. As Representative Meza told you, Texas is the national leader in solitary confinement by a large margin. With a restrictive housing population of almost 4,500 as of December, no other state keeps even half as many people in solitary confinement. And as you heard, Texas is even more of an outlier in terms of long-term restrictive housing. TDCJ holds more people in restrictive housing for 3 years or more than every other state and the federal government combined. At least 3/4 of the people in restrictive housing here stay for more than 6 months, and yet Texas prisons are no safer than any others. This overuse of administrative segregation, especially prolonged isolation, serves no one. Spending even a short period of time in administrative segregation can have devastating and permanent effects on a person. For decades, experts have documented the psychological distress caused by solitary confinement. Common symptoms include anger, boredom, stress, loss of a sense of reality, suicidal ideation, trouble sleeping, lethargy, impaired concentration, confusion, memory loss, paranoia, hallucination, and depression. Physiological symptoms are also common, including headaches, heart palpitations, sensitivity to noise, muscle pain, problems with digestion, loss of appetite, and dizziness. These symptoms can set in after only a few days in isolation and may persist even after release. In this post-pandemic world, we can all appreciate with a new level of understanding how difficult it is to exist in even a limited form of isolation. Restrictive housing deprives people of the basic activities that make us human. People go years without hugging a loved one or seeing the sun. There is no reason to deny people these basic human dignities for years on end. Spending time in prison is enough, and solitary confinement costs taxpayers even more than prison does ordinarily, largely because of the greater staffing needs, which is even more burdensome given the current crisis of understaffing in TDCJ. To be clear, HB 812 still allows TDCJ to use administrative segregation to de-escalate dangerous situations and ensure staff and prisoners are safe. Following an incident involving serious bodily injury, staff can still isolate the perpetrators for more than a week while they determine appropriate and secure housing options. The vast majority of people in prison will return to their communities, as you've heard, return to our communities one day. By limiting the time people can be held in isolation, HB 812 gives them the best chance possible when they return home and makes our communities safer for everyone. We urge you to support this sensible and humane legislation. Thank you.
Thank you. Any questions, members? Thank you so much. Anyone else here wishing to come forward to testify for, on, or against House Bill 812? Charlie Maloff. Hold on, sir. I'm sorry. Hold on, Charlie. Sorry. Sir, I've called Charlie Maloff. I'm trying to figure this out. Charlie, let's see. Charlie, I don't see your name on this bill.
It was the first one I registered for.
I understand. For whatever reason, the computer is not pulling your name up. Here, once again, sometimes obviously there's technical difficulties. Here's what my concern is as we move forward. I'd like to get other bills. We're going to be running really short on time because we have to be done by 1 o'clock. And so trying to make sure here that we have the individuals. Charlie, while we get you registered, Miranda, do you know the name of the other individual? No. Have you registered?
Apparently hit the wrong button. That was one of I did register, but
Can you come up for?
another bill too that I was.
Let me do this. Charlie, can you come up, give me your name, and let me know that you're registering, and then I'll call.
Can we do email first?
Who?
Can we have them register the
Yeah, go ahead. So we're going to run into some time crunches, serious time crunches. So we're only going to be able to probably get to one bill maybe after this, maybe two at the most. So
Thank you.
Hold on. Chair, at this time, we'll call Charlie Maloff. Please go ahead, Charlie.
Mr. Chairman, Vice Chairman, members of this committee, my name is Charlie Maloff. I'm representing myself, and I'm representing Texas Cure. Additionally, I'm formerly incarcerated and a veteran, and we are for 812. This bill lays out limiting the use of ag-seg. You can call it administrative segregation, but the fact of the matter is it's solitary confinement. Having been locked in seg twice, once for 54 days and once for 69 days for no reason, meaning no infraction or disciplinary action, solely administrative retaliation because I was trying to access the law library. In other cases, inmates in SEG set fires because they were being denied meals and access to medical for serious medical conditions. They got sprayed down with pepper spray for causing a disturbance, then left for days before they got a shower. Or like in my case, because SEG requires a guard escort to the shower, I was handcuffed behind my back by a psychotic Nigerian guard just under the elbow, so tight my lower arms were purple and numb by the time we crossed 50 feet to the shower, to and from every day for most of those 54 days. This conduct is unconstitutional and unacceptable. Do not tell me this or long-term condition is an effective prison management. If this state is going to practice ongoing long-term solitary confinement, it needs to conduct in-depth studies in conjunction with the U.S. military on psychological effects on a person in these conditions. During a SERI training exercise, those of us captured were subjected to solitary confinement housing in conditions by a 4-foot by 4-foot by 5-foot box. I had to listen to a telephone ringing over a loudspeaker 24 hours a day for 3 days. The point is, long-term isolation in conditions such as in TDCJ creates PTSD problems, not solves them. And most all prisoners not sentenced to death or life without parole, at some point, are going to go back into society. Prison is supposed to be about rehabilitation, not intentionally adding unnecessary mental health burdens and property damage repairs on the taxpayers. When a prisoner is involved in an altercation involving serious bodily injury, the inmate is given a major disciplinary case, a loss of line class, and parole. Then they are transferred to another unit. Depending on the outcome of the investigation, they can be given free world assault charges and additional time on their sentence. Misconduct can involve a number of issues, but ag-seg is involved. There's also the major disciplinary case, loss of line class, and parole. A majority of these cases do not demand ag-seg for prolonged periods of time. The bill is smart justice, and thanks for the opportunity to present it for your consideration.
Thank you, Charlie. Any questions, members? Thank you so much. Appreciate your testimony. Van Holly.
Thank you, Mr. O'Hara and panel, ladies and gentlemen, for the time to talk. My name is Van Holly. I am for this bill, and I represent myself.
Please proceed, sir.
Our son Will, like many others, have not had human contact by family for over 7 years. He got a 40-year sentence when turning 20 years old. That's an entire adult life. The need for companionship and the environment led him to make friends with mice and insects in the segregated cell. Will is housed in segregation, having volunteered currently for a 6 to 9 week program for those who have been incarcerated in segregation for long periods, with the understanding that it improves classification status and the ability to return to general population housing. These programs receive government funding, yet he is still waiting for the groups to meet 3.5 years later. He still is living isolated in restrictive housing and trying to maintain his sanity. And TDJC is still collecting funds for these programs, which he is not benefiting from. Who is truly overseeing TDCJ? TDCJ must have independent oversight, and fair treatment is to be standard in cameras always turned on and in working order. We have housed individuals who exist in solitary confinement for years upon years with 23 to 24 hour a day, tending to their hygiene mostly in the small sink that's in their cell. The food trays are scantily prepared, non-nutritional, and contain rodent feces and cockroaches due to sanitary conditions depending on the unit. The TDCJ housing in many units have plumbing problems, leaking pipes, which cause mildew and mold. The summer months are well above 100 degrees, humid and hot. The concrete buildings absorb the heat, and it is documented that it is a sweltering habilitation who may suffer heat stroke. We are the voices for the forgotten, those labeled undeserving, but they are a human population of mothers, fathers, sons, and daughters. This is not a third world country. This is the criminal justice system in Texas. It's the best we can do to uphold each individual's rights in our great state of Texas. I'll leave with this question. My son asked this question to me. I'm punished 24 hours a day. I am trapped in a tomb all alone. I have lost loved ones and friends who have forgotten me. I have feelings. I am human. Don't I deserve to be touched or feel that somebody out there cares? Thank you for your time, and I appreciate it.
Yes, thank you. Representative Swanson.
Thank you, Chairman. My just sympathies on your family's situation. I'm honestly trying to understand all this, and it may get into perhaps things that you don't want to say about your son, but help me understand, how does a person end up in solitary confinement? Was it based on his original crime that he was convicted for, or something that happened once he was in prison? And then why did they keep him? I mean, there's got to be a reason, whether we agree with it or don't agree with it. And then at some point, I would like TDCJ to be able to give their side of the story on why such a program is apparently not going on. Go ahead. Like, how did he get in there? Like, why do they think he's still a danger?
That's a good question. Real quick, I'll tell you what happened. He had met a guy. He was 19 years old, 18 years old. Met this guy had already been in prison. My son had a drug problem. They were looking for money. They went to a station late at night. Will was a lookout. The gentleman robbed the station, got the money, no problems, but he took a step back and shot the clerk.
The other guy did?
Yes, the other guy did. Even the police said your son didn't know he had a gun because watching the video, which I saw, he jumped. Like, what was that?
Okay, I know we're short on time. I have to interrupt.
Gotcha.
Why did he end up, I think we have lots of people like that who are not in solitary confinement. Why is he in there? Why did he stay in there?
He caught a couple of cases, and then...
Caught a couple of cases? Oh, he got convicted of other things while he was in prison?
cases in prison that you're not supposed to do.
Okay.
He put a sheet over the window because he was taking a bath in the sink. He didn't want a lady officer to walk by and see him because that's a violation too. But he had the sheet over. They asked him to remove it. They said, not until I get dressed. He ended up in solitary confinement for it. 20 years. That's one. He had another one. The other thing, he was taking this courses in Tennessee Colony when the pandemic hit and they stopped all the classes. He was still in solitary confinement at that time. During the pandemic, they moved the classes. 84 of them moved overnight, prisoners, to Polanski and Livingston. Do the classes there. We waited a month or two, went and talked to the warden. He said, you know, I got a call the day before that 84 prisoners were coming over for classes. No instructors at all. So he has stayed in Polanski in solitary confinement. He just, within the last month, got put back in a class. They met once and they haven't met again since then. He cannot get a different classification until this class, and he graduates from this one class, and it's a 3-month class.
Okay, I just would hope TDCJ, I'd like to ask them for more information because I don't believe anybody stays in solitary confinement for a sheet over the window for that long. There's got to be a lot more to this story.
Yes, they do. Yes,
really?
They do.
Well, then we need to hear from them. Okay, thank you.
And by the way, you know.
Hold on, please. The only person that should be speaking would be the person that we've recognized, which is the member at this point, and then if you have an answer to that question. But any other questions? No, thank you, sir. Appreciate it.
Thank you for your time. Appreciate it.
Thanь you as well.
Sorry I wasn't registered.
That's okay. We'll try to get to everybody as soon as we can. Is there anyone else that wishes to come forward to testify for, on, or against House Bill 812? There being none, the chair will close the testimony for House Bill 812 and recognize Representative Mesa to succinctly, expeditiously close on this bill.
You don't know me well, do you? No, okay. Yes, I'll try. Thank you to all the people who came here today to be witnesses. Some drove from not so far away, some from further away. It's important to hear their testimony because they lend their face and their story, their personal story, to this bill so that you can understand it better. Yes, people can be placed in solitary confinement for having done nothing. Or you may have missed the one witness who testified that she was put in solitary confinement because she hugged somebody and that was against the rules. So it could be very minor infractions that we wouldn't even think would be something that someone would be put in solitary confinement for. We'd think it'd be something like stabbing somebody in prison or something like that, something super serious. But they can be put in solitary confinement for having done nothing. If you think the sheet over the window or the hugging somebody sounds bad, they could have committed no infraction in prison and be put in there because, as one witness testified, if they suspect that you are part of a group, a targeted group, which I think may mean that they think you're a gang member, but really that you haven't done anything wrong, they just suspect you're in a group, then you can be put in solitary confinement. So I hope that goes a small measure toward answering your question, Representative Swanson. Then comes the issue, if you agree with me.
Representative Mesa, I really do apologize, but we really got to try to get to the next
I
bill.
understand. One last thought, and that is that how long is too long? Are decades too long? I think so. Years too long? I think so. Months too long? I think so. So then we get down to weeks or days, and that's what I'm asking you to consider, is that not to say, we're not saying here today that we're not going to take away from the criminal justice system the right to put someone in solitary confinement, but for how long? Not so long. So I hope that you'll consider to limit the use of this practice in our prisons to a maximum of 10 days, because otherwise it constitutes inhumane treatment and torture. Thank you.
Any questions, members? There being none, at this time, the chair, thank you so much. Well, if there's no objection, leave House Bill 812 pending. There being no objection, House Bill 812 is left pending. Chair, now at this point, will lay out House Bill
1064.
House Bill 1064 and recognize Representative Sherman to explain the bill.
Thank you, Chairman Herrera and members of the committee. Thank you for the opportunity to lay out HB 1064. This bill seeks to expand the ability to earn time credit toward people eligible for more of those incarcerated by the Texas Department of Criminal Justice. Earned time credit programs help put the focus of serving prison time back onto rehabilitation rather than retribution. This bill would allow more people in prison to earn parole eligibility, but release is not guaranteed for anyone. It would provide an incentive to participate in productive activities as well as hope in an otherwise hopeless situation. Earned time credit would also create safer environments for inmates, correctional officers, and other TDCJ staff. It would then provide the parole board with more ways to evaluate individuals in TDCJ while maintaining their discretion in decision making. HB 1064 provides an incentive for all offenders with parole eligibility to make the best of their time incarcerated. This bill doesn't shorten sentences, but it provides more opportunities for some of the sentence time to be served in the community. President Trump signed into law the First Step Act, which is also the same as earned time credit. Thank you again, Chairman Herrera and members of the committee. I reserve my right to close.
All right. Any questions, members? There being none, the chair at this time will recognize that Representative Sherman has reserved the right to close on House Bill 1064. And we're 9 minutes away. So at this point,
No.
Yeah. Here, let me do this so that people know that we will be on this bill when we come back from the House floor before starting to open up the public testimony on it. We're going to go ahead and recess. All right. Let me, because we're short on time, and I know that members and everyone else has to someplace to get to, and I apologize that we're not able to accommodate everyone. But we'll go ahead and open up public testimony on House Bill 1064. This time the chair will call Shelley Sexton.
Thank you. I'll be succinct.
Yes, please.
Okay. Thank you. My name is Shelley Sexton. I'm representing TIFA as well as myself on this bill, and I am for the bill.
Perfect.
Okay. All right. So House Bill 1064, the Earned Time Credit Bill, encourages inmates to participate in rehabilitation and skill building to transform their lives through education, vocation, treatment, and work programs completed during their prison sentence. Time earned through these programs give all people incarcerated by the Texas Department of Criminal Justice a chance to work towards an earlier parole board hearing date. It has long been time to pass a person-centered legislation that allows people to be evaluated as individuals and the work they are doing to prepare for a productive life after incarceration, rather than categorized by the crime for which they're serving time. We are not asking for thousands of incarcerated to be released into society at the passing of this bill, only to let them see the parole board earlier than half of their sentence. The parole board will evaluate their progress and will still give them a set-off for heinous crimes or make the decision to release them. Earned time credit legislation is known to reduce state prison expenditures by reducing the prison population and reducing recidivism rates. Earned time credit gives incarcerated people hope during a hopeless and dark period of their lives. This bill encourages rehabilitation. They currently have nothing to lose, which compromises safety for TDCG staff, guards, and other inmates. My personal testimony, my husband's incarcerated for aggravated robbery of a convenience store where he used an unloaded airsoft pistol used by youths to play airsoft games. He never brandished the weapon, only showed it in his waistband. He received a 30-year aggravated sentence. Once incarcerated, he entered a faith-based program, which changed his life. God will do that. In the 5 years he's been incarcerated, he's received an Associate's of Arts degree, a bachelor's degree in ministry, and is currently 4 courses away from his master's in Christian counseling, after which he'll enter a doctorate program. He works 10-hour days in the furniture factory at Ramsey. He attends church every Sunday and has brought many people to Christ. He has completed dozens of courses to better himself as a productive member of society, everything from anger management to Bridges of Life and the Alpha courses. I continue to be amazed that a man who is severely abused by an alcoholic father and left to fend for himself on the streets of Texas has made such a life-changing difference in his own life and the lives of everyone he touches. His story is one of many of the men and women in TDCJ who are rehabilitating themselves. Let us then approach God's throne of grace with confidence so that we may receive mercy and find grace to help us in our time of need. Hebrews 4:16. Thank you for your time. Please send House Bill 1064 to the House floor. How's that?
Perfect. Very good. Any questions, members? There being...
Mr. Chairman.
Yeah, Representative Sherman.
Could I just say something? I know.
Yeah, go ahead.
I appreciate this, and I'm grateful to the chairman for your consideration. I have to get back for a funeral for someone who is like an aunt to me, and I certainly hope that I did not offend any family members for reading rapidly the bill. This is a very important piece of legislation, and if some today were alive then, I doubt that Saul's conversion would have been convincing to them, and we wouldn't have the epistles that we have today. And I just want to say this, my written statement, Chairman, is in 2018, President Trump signed into law the First Step Act, which was the culmination of a bipartisan effort to improve criminal justice outcomes and positively impact public safety. The majority of states have some type of earned time credit program and have seen benefits such as lower recidivism and lower costs. If Texas passes this bill, we will be a part of the list of 38 states that have implemented some type of earned time credit program, which includes several Republican states such as Florida, Alabama, Kansas, Kentucky, Louisiana, Mississippi, and Oklahoma. This is not about Democrats or Republicans. This is about the people of Texas demanding that the state stop allowing fear to trump prudent first steps that lower recidivism and save taxpayers money. As legislators, we must be rational about how public safety is administered, leveraging in closing a balance of punishment, rehabilitation, and mercy that is granted to each of us by our Creator. So with that, Chairman, I am so grateful for your grace in allowing me and members to allow me to present and lay out my bill.
You're welcome, Representative Sherman. Any questions of Ms. Sexton? Thank you so much. Thank you for your testimony. Thank you for your time and your understanding as well. It is 12:58, members, and we do have to be on the floor at 1 o'clock. So therefore, at this time, we will halt public testimony for House Bill 1064. And before we head to the floor, we'll be leaving this bill pending. Are there any objections? Hearing none, this bill, House Bill 1064, is left pending in committee. Chair moves that the committee stand in recess until final adjournment, recess of the House, or during the bill referral if permission is granted. Is there any objection? Hearing none. It is still 12:58 p.m. and the committee House Corrections stands in recess. Thank you.